Hi. Today we'll be talking about government contracts or contractual liability of the state. A contract is between two or more parties. A government contract is a contract in which the government or some government authority is one of the parties and the other party are private individuals. With the increase in economic and welfare activities of the government, it is important that the government has the power to enter into contracts. For example, contracts to sell or purchase property, contracts during carrying out of businesses, insurance contract, and so on. In this video, we'll be discussing Articles 298 and 299 of the Constitution. Article 298 gives power to the state to enter into contracts for any purpose. Article 299 gives the mode and manner of entering into a government contract. The language of Article 299 is technical, strict, and mandatory. Article 299 lays down how government contracts, including assurances of property, are to be made and executed. Assurances of property mean any documents of conveyance. Those are legal evidences of transfer of property. Let's have a look at what 299 contains. Firstly, 299 states that all contracts must be executed by a person authorized by the President or Governor. Secondly, it states that contracts must be executed by such persons on behalf of the President or Governor. And thirdly, it states that contracts must be expressed to be made in the name of the President or Governor. The word executed means that government contract has to be in writing. A written contract is necessary. Unlike contract between private parties, there cannot be an oral agreement. Also, there cannot be an implied agreement. All government contracts must be express. Normally, contracts entered into under Article 299 are by executing formal documents, but there have been cases where mere correspondence through letters or written offer and acceptance is held sufficient to constitute a government contract. A contract has to be entered on behalf of the government by the person authorized by the President or Governor, as the case may be. A contract which is executed by a person not authorized for the purpose is void, and it's not a contract at all. Article 299 has been made to safeguard the government from unauthorized contracts. As I said before, Article 299 is technical, strict, and mandatory. A legal relationship of contract is created with the government only when provisions of Article 299 are strictly complied with. No suit can be brought against the government, whether union or state government, if the requirements laid down under Article 299 are not complied with. Similarly, if a contract is not according to the provisions of the article, government too will not be able to enforce it. Though the government contracts are made in the name of the President and in the states in the name of the Governor, these persons are not personally liable in respect of any contract. Similarly, the persons authorized to are not personally liable since they are acting on behalf of the government and not in their personal capacity.